We did write a demand letter, and this is the response from Safaricom. It's a letter dated 24th February 2026. Read demand notice dated 19th February 2026. MCCR stroke E1161 stroke 2024. R versus David Mokaya. Safaricom writing, we acknowledge receipt of your letter dated 19th February 2026. Having reviewed the judgment made on the 19th February 2026, Safaricom does not admit and expressly denies any liability as alleged. We draw your attention to the fact that the trial court made no binding determination of civil liability against Safaricom. Further, we are of the view that observations in the judgment concerning investigative practices cannot be construed as imposing strict constitutional liability on a telecommunications provider acting in compliance with formal requests from law enforcement agencies. Any suggestion to the contrary is misconceived. With this in mind, your ultimatum requiring Safaricom to accept liability and offer compensation within 48 hours, including the asserted figure of Kenya shillings 200 million, is unequivocally rejected. This response has comprehensively addressed your concerns, and any litigation will be vigorously and robustly defended. Yours faithfully, Wangeshi Gishuki, Head of Department Legal Services for Safaricom PLC. That was the response to Mokaya's demand. Safaricom has called a judgment of a court as mere suggestions, because Safaricom is the bigger judge of this country. Safaricom has arrogated itself the purposeful decision to disclose personal data of citizens of this country and any foreigner in this country. Safaricom was there when the Data Protection Act was being made. If they wanted, they could have lobbied Parliament to say Safaricom can disclose any data to anybody without a court order. The act is very, very clear. Only through a court order. The reason why the police come to court under miscellaneous application to get a court order to seize gadgets of people is because they are in compliance with the court order and with the law. Safaricom, remember, thousands and thousands of Gen Zs were located and picked. Many were killed. We are not talking about a violation that has not resulted to very many Gen Zs being killed. Insensitive to what Safaricom has done. 3 times the CEO has been trying to sanitize their actions, that they never gave the police information where the young Gen Zs were. In their own admission, they admitted that they gave information of the whereabouts of Mokaya without a court order. Safaricom has been cheated that Mokaya will go to the Data Commission, where the maximum is 5 million shillings. This is a constitutional violation. This is an affront on the Bill of Rights. This is an affront on the marginalized group like the Gen Z, who are almost 3/4 of this country. We are determined. They have said they will defend robustly. We have filed, we will prosecute viciously, and we shall be calling upon anybody who has been aggrieved by the action of Safaricom to come to us. We shall pursue this matter because this is about the safety, security of young people and citizens in this country. The police know very well they do not have rights to access the telephones and data of any citizen of this country without a court order. But Safaricom is defending an act that is illegal, an act that is unconstitutional, an act that violates the primary consideration of the privacy of any citizen. It is the only entity. No bank has ever given the police information without a court order. No entity in this country, all of them you must have a court order, except from Safaricom. Safaricom has decided to enter into a boxing ring with Mokaya. We will see he who loves last loves best. Mokaya was traumatized. He was picked as a petty thief, put in the Subarus of the DCI, transported from Eldoret, a distance of over 350 kilometers, inside a police booth. This young man has seen it all. But this is going to be the face that will bring Safaricom down. This is heading to be, we are heading to a class suit. And that's why we are heading and calling all people who Safaricom has disclosed their details. We shall be seeking an order to be allowed, we serve in the media for anybody interested to join in this matter, so that Kenyans and any foreign whose issues have been disclosed to join. Let's see what the judge says. But as we said, Safaricom has said the judgment of a court is a mere suggestion. Let's see how the courts deal with this matter. Wale ambao hawajasikia kwa kizungu, tumesema tumeshtaki Safaricom kwa maovu waliotendea Mokaya. Walipeana information mahali alipo, akakamata. Wengi wa Gen Z waliuawa sababu Safaricom iliweza kupeana mambo yao bila court order. Tunatarajia kwamba tutapata na tutafaulu kupata shilingi milioni 200 iwe fidia kwa ukijana. Na tatu, tunatoa ombi kwa wale wote ambao Safaricom imedhulumu kwa kupeana details zao, waje kisha wajiunge na hii kesi, ili tuweze kuonyesha Safaricom kwamba Safaricom iko chini ya sheria na katiba ya Kenya. Asante.
We are gathered here today as Danstan Omari and Associates Advocates, and we are graced with the presence of our client, one David Mokaya, who was recently acquitted by the court in Milimani, Criminal Magistrate Court, for crimes that were fashioned against him. And the judgment acquitted him, saying that indeed the prosecution failed blatantly to prove beyond reasonable doubt as to his culpability. Following the judgment of the court that was delivered, we noted that the court indicated that the service provider, being Safaricom PLC, had illegally given information, personal information, derogating our clients' right to privacy and derogating our clients' fundamental rights and freedoms. Subsequently, we wrote to Safaricom PLC to admit liability and forthwith compensate our client for the mishap on their part, and we gave them a timeline of 48 hours. On the lapse of 48 hours, all the legal minds have met and decided on the way forward, and we have filed a constitutional petition before the Constitutional Court in Milimani, since we are seeking an award of 200 million in damages from Safaricom. This is going to be a landmark case because we're in a season of the country where many people are being kidnapped, innocent youth are being kidnapped on the basis that the investigating authorities are going to Safaricom without a court order or any other telecommunication company without a court order, and they are giving information about citizens of this country, especially the youth, which then follows that our youth of the country are being kidnapped left, right, and center without any court order, or they are being subjected to the criminal justice system without undue procedure and regard of the law. We are hoping that in fullness of time we are going to see the light of day, and this will serve as a teaching lesson, especially to Safaricom PLC, for what they did to our client, who is a living example. They have responded and they have noted that the court did not mention anything about their civil liability. Be that as it may, there is no mandate of a criminal matter or a criminal judgment that mandates a judicial officer to decide or determine whether there is culpability in the criminal division. And therefore, we know very well that based on the examination in chief of one of the witnesses by Safaricom PLC, who was PW5, they admitted to giving information without a court order, and that was an admission of liability in fact, and therefore we will be vigorously and zealously representing our clients in the few coming days. That is all.
Now we are here at the invitation of Mr. Mokaya to represent him as he seeks the compensation for the violation of his rights. As you might be well aware, this is a gentleman that was arrested on the 13th day of November 2024. He has had to endure for a period of about an year or so the vigorous trial before the Honorable Court here at Milimani Law Courts pursuant to charges, flimsy charges that were levied against him. Now, after his triumph on the 19th day of February 2026, we've had to do a small postmortem so that to identify what led to his arrest, to identify, the gains that comes with the disadvantages that he was placed in during the period of time that he was enduring the trial. Well, after the postmortem was conducted, we realized that pursuant to an admission made by one Mr. Hamisi, an officer from Safaricom PLC, who was called as a fifth witness for the state, there was an open admission that the arrest of Mr. David Mokaya on the 13th day of November 2024 was actually instigated by Safaricom PLC without any lawful authorization. This is to mean that acting on a letter written by the DCI and without any lawful justification, Safaricom PLC led the investigative agencies to the location or the house of Mr. David Mokaya that led to his arrest. Well, we are a constitutional democracy. Safaricom PLC is not above the law. The DCI is not above the law. All of us are subordinate to the Constitution of the Republic of Kenya, promulgated on the 27th day of August 2010. And for that reason, through the instructions from our client, we have decided to call Safaricom to order, if not for Mr. David Mokaya, but for the sake of the posterity of this country. So that moving forward, Safaricom PLC will not be acting as or in the manner that they did, thinking that they can be greater than the Constitution, while it is the Constitution that has given them a space to thrive commercially within the Republic of Kenya. So for that reason, we have filed a constitutional petition before my lords in the Constitutional Division, inviting the Honorable Court, by looking side to side, the decision that was rendered by the Honorable Magistrates Court that led to his acquittal, the preponderance of evidence that was presented by the state during the time that he was facing prosecution or persecution for that matter. We have invited the court to interrogate the evidence and the material and arrive at the conclusion that indeed Mr. Mokaya, David, being a citizen of this country, is entitled to certain rights and fundamental freedoms. One of them being the protection of his right to privacy. And we have also invited the court that after making the determination that indeed he is entitled to the right to privacy, that indeed his right to privacy was violated. And it was violated without any lawful order, which has been admitted before the magistrates' court. So we thought that it will be in their best interest to accede to our invitation for an out-of-court settlement in this matter. But lo and behold, they declined the invitation. We have just received a letter through our senior, Mr. Danstan Omari, Safaricom declining the invitation for an out-of-court settlement. Well, there is no problem. It's just fair enough. We just hoped that, pursuant to Article 159 of the Constitution, which invites us to, resolve conflict by way of negotiations or reconciliations or arbitration, that they would accept that invitation. But now that they have declined, the question is before the Honorable Court. We'll be inviting the court, as we did in our letter, to make a determination that Mr. David Mokaya is entitled to a compensation of up to a tune of 200 million shillings. This will be not only a compensation to Mr. Mokaya, but will also send a very strong message to Safaricom and other telecommunication, these mobile providers, be it Airtel, be it Telcom, all of them, that given an opportunity, when they receive an invitation from the DCI, that they should always be keen enough to identify whether the invitation from the DCIs or the investigative agencies has been made pursuant to a court order. Because it is only through the limitations made under Article 24 of the Constitution that someone's right within the Republic of Kenya can be limited. And it can be limited by law, it can be limited when it is reasonable and it is justifiable. So